So,
Okay, good afternoon, commissioners, and to the general public. This is the March 1st, 2024 meeting of the Criminal Injuries Compensation Commission. I call this hearing to order. We'll start with the agenda. The first item on the agenda is the roll call. May I please have everyone identify themselves and their presence. Starting with Dr. Flores.
Lisa Flores, present.
Holly Mike Chrysostom, present.
And Elizabeth Barrett Anderson, present, chair of the commission. Emma Jean, could I ask you on the next item on the agenda is to read the open government compliance requirements.
The meeting and agenda were posted in the Guam Daily Post on February 23rd, 2024, and February 28th, 2024, and further posted on the Office of the Attorney General website, as well as the Government of Guam Public Notices portal as required by law. The meeting is being live streamed on YouTube channel.
Thank you very much, Emma Jean. Commissioners, we have minutes from our September. We'll look to the minutes now. That's the next item on the agenda. Our September 22nd hearing. I'll give you all a few minutes if you have had time to review that. I have reviewed this with Energy.
Yeah.
I want to thank you, Jean. You got the minutes done within a few days after that. That hearing, fresh in your mind and fresh in my mind. So I have reviewed this with Energy. I'll give the commissioners a few minutes to look through it.
I'll make a motion to go ahead and accept the minute and subject to amendment.
Do I have a second on that? Okay, all those in favor say aye. And the minutes have passed subject to, I'll say correction, postponement of correction. Thank you. The next item on our agenda is some of the new business. We always try to get an idea of where the CICC fund and the fund level is at. We did have a report from Commissioner Viola last time that nationwide, the criminal injuries allotments to the various states and territories has gone down significantly. And that is for the BOCA as well as for the compensation funds. Imogen, can we have a report on our local CICC funding level, both, can you split it between the local and the compensation amounts?
I have the local here.
Yes.
The CICC fund has $1,235,591.32 as of February 27, 2024, from the OAG Financial, based on accounting from the Department of Administration. This amount does not include amounts paid out from the September 2022 meeting.
Okay, can you give us an idea of the process that those approved amounts are going through and what the status is of their payments?
So the amount were initially, the paperwork with the funding requests were initially routed to the Department of Administration on January 31st, 2024. And then it was routed again on February 20, 2024, because of the Department of Administration system. Well, they have a new system. And so we wanted to make sure whatever was not I guess they said, refunded, and that's what we said, so they're currently funding with the Department of Administration.
Do you have from reporting the amount of the compensation, federal compensation contributions to law? Do you have that language?
Not.
The last I remember, we were around 280,000 when I testified last summer in front of the Oklahoma legislature. Because we have not been able to approve awards due to the statutory issues that we had, we really haven't given out any very much last year. I think the only thing we gave out last year would have been into September. And if we are to receive, what is it? I think it's 75 cents on the dollar, or is it 65 cents?
I need to confirm your honor.
To every dollar that we award out, the federal government through the VOCA fund will give us, I believe it's 75 cents on the dollar. But if we don't award out because of any difficulties in our being able to process applications, then we don't, we can reimburse. What we'll do is we'll request then that Emma Jean give us an idea at our next hearing of where we stand on the federal compensation reimbursement, but we should still be around $200,000. Any questions to Emma Jean regarding Commission's current fund? That I just want to remind all commissioners, this fund is protected by law. It cannot be touched. It cannot be moved for any other purpose by any government official without the approval of the Attorney General and certainly information to the Commission. So it's a protected fund. Sometimes when you see that kind of money in the government funding, is somebody going to try to use it for something? No, it's just it's in the special fund, and not special because it's special, but special because it's ours. And so no one can touch that. It stays. All right, the next item on the agenda is our annual conference. Yes, and Jean, when, where is the summer annual conference of the Office of Victims of Crime?
So we received notice for setting the date. They have it set for August 5th through 8th, 2024 in New Orleans.
Second. Save it. To save the date. I won't save it if I don't write it down. Again, in August what?
5th.
Last year, Commissioner Mendiola went to the conference. It was a Chicago conference. I would like to propose that we send a commissioner, Emma Jean, from the commission. And the reason why I think we can send two is we do have, and Emma Jean, please find we have federal funds to send you as our administrative assistant or jack of all trades and a commissioner. In addition to the federal funds, I requested approval of the Attorney General and the Guam legislature for travel funding from local money. So we have a local travel and we have our federal travel. And that doesn't hamper the requirement of the Attorney General's office to send under our Victims of Crime Act, the administrator for the VOCA. But we have the ability to send the commissioner and Emma Jean. Denise had gone. Emma Jean had gone because she was the VOCA administrator here. And who is interested in going in August? I am not interested. Don't be shy.
I yield stuff.
That's why, we wanted to talk about it today, because I'd like to make a request to the Attorney General's office soon. It's save the date. If you, don't want to make any commitments right now, why don't we just think about it? I want to let you know, I will not be going. I have a scheduling issue and some things happening in the summer. So keep an open mind. And maybe we can handle this again. We're gonna try to have another hearing, in April. So by April? Yes.
Because we have reassigned in July. So I'm not sure where I'll be.
In your job?
Yes. So the pastors are being, briefs are being reshuffled.
And you can't, if you are one of the reshuffled, you can't necessarily leave when you're.
Because we will effective to be July, we have effective dates. And so leading in August. we'll
Yeah.
have to be in it.
It's like, here's your new job, but you're gone.
But I don't know yet. We'll see. I don't know if I'll be moved, but
But this is always an on-island reassignment, right?
correct. Yeah, it's typically there. It's in every 6 years. So it's been that long.
Sounds like Department of Education, the teachers are reassigned. Was there anything else about the OBC conference in New Orleans that you wanted to let us know?
I believe there's a survey, so I'll forward that. I think it was asking for something, but I'm not sure if it might be relevant. I'll just go
Is
ahead.
that the rules? There are new, federal rules and regulations that I looked at.
I think it's probably more detailed towards the actual conference. I think they usually have presenters or people that are volunteering to showcase the programs.
I've done that before, not to the commission, but on other things. Guam, would have a booth or we present a lot of work. You know, it'd be nice if Guam and Hawaii got together and we did a presentation at OBC. They rarely know about us. But weird. Oh, by the way, Emma Jean did participate. Did you say you participated in an OBC conference call?
Yes.
At 4 a.m. Guam
5
time. 5 a.m. Guam time. Thank you very much, Emma Jean. And it was I wanted to let the commissioners know what that conference call.
So there was a new director, Mr. Bronson, and Jolita, who is our grant specialist, who is very actively involved with us. I appreciate her a lot. Had sent out invites, and so I made an effort to appear just to, meet who the new director is and make sure that we, the commission, and represent and also to invoice our concerns about address their concerns about the shortfall coming first 2024.
And it's still an issue. I'm just so glad you woke up at 5 o'clock in the morning or 4 o'clock in the morning to get your coffee and
Me too.
make your presence known. I'm sure they were quite surprised and appreciative of Guam being there. So Mr. Bronson is the Director of Office of Victims of Crime,
He has a specific role, Your Honor, a specific title.
but not the overall. Oh, okay.
He has, he's under the credits. She had us, Jolita had us in different groups, so it wasn't off of these states and territories that was broken down to.
And Emma Jean said that Guam was grouped with the East Coast, and I said, Emma Jean, do they know we are not in the Caribbean? We're in the Pacific. I thought, we'd be grouped with Alaska, Hawaii, California, but she was grouped with the East Coast states. And it gave me a thought that maybe they thought Guam is somewhere in the Caribbean. We'll make sure that they don't make that mistake. All right, next on the agenda is our budget. I'm going to recommend that we present to the Attorney General just a ditto budget from 2023. I'm sorry, FY 2024. If I recall, our request to the Attorney General and to the legislature was for $65,000. That a majority of that was to pay for a program coordinator. I don't know if, Imogene, your salary is coming from that budget, but I leave that to the Attorney General. We also have supplies, equipment, nominal amounts, and 5,000 for travel, so. May I suggest that for 2025, we simply ditto our request to the Attorney General to the legislature. I believe it was around 65,000. Okay. So do I have a motion to ditto the same? Is there anything else that we have to think of that we need? Do you want to think about, do you have any financial, amount that we would have to request to do an outreach? It's mainly printing, I guess, printing. Is there advertising cost in that? The Attorney General's office is required to submit its budget in March. I don't know if it's for, oh my God, it's this month. Yeah, March. Okay, I'm thinking March 30th. The governor, I believe, needs to get her budget down in January. But from what I recall, unless it has changed, it used to be the end of March, we send it down. So from this hearing, we need to get a memorandum to the Attorney General.
I think it was just, if I recall the recommendation, was just to print brochures so that we could feedback off of the other resources that are out.
Then I think we still have some money, supplies. I might have requested $2,500 in supplies. Oh, right. So we'll just do it over 2020 and by 2025, and I'll get that memorandum to the Attorney General this next week. So we can just include it in his budget submittal to the law legislature.
I think.
Yes, please.
Oh,
All those in favor? Aye.
got it.
Yes.
We have better see it. When did I see it?
Well. Oh, yeah. Yeah, we did. Let's go on.
Right.
All right, let's go to the rules and regulations. One of the most important things we're doing here today. What I'd like to do at this time, Commissioners, is ask Will, are there any other members of the public that are in the chat group? Is that what it's called, Will?
Yes, we need to double check.
Because I'd like to identify those members of the public who would like to participate and to listen and to add comments on the rules and regulations of people.
Right now, you're looking at the Zoom or looking at the live hearing on the YouTube. So there's nobody in there yet.
Will, if someone does come in, please interrupt
Yep.
the commission so we can identify the person who wants to participate in the review of the commission of the rules and regulations and make sure that we have full public comments at this time.
Okay. Got it.
Commissioners, what you have in front of you, and I believe Emma Jean had forwarded, first of all, my thank you. Emma Jean had forwarded the draft to most of you prior to this meeting, so you could become familiarized with it. The draft, Will, can we pull it up on screen now? This is a 2024 draft of the rules and regulations for adjudication of victim compensation. The base of this draft is our 2016 approved rules and regulations. And this hearing today is to update those 2016 rules and regulations to incorporate Public Law 37-40. Protecting confidentiality of victim information in our applications. And it was also an opportunity to make some good changes. You'll see them marked in red as we go through page by page. Okay, so again, one more time, the base is the 2016 approved Rules and Regulations Act. Just remind the commissioners that our rules and regulations failed promulgation with the compiler of laws because those 2016 rules and regulations were submitted to the legislature via the Speaker's office, directed to the attention of the legislative secretary, which is required by the administrative adjudication law. Once rules and regulations are approved and they go through the hearing process, reviewed by the attorney general, they go to the legislature for 90 days. And after the 90 days, those rules are promulgated, approved, deemed approved by the legislature, and then sent to the compiler to be published and promulgated. According to the compiler, those 2016 rules should have been addressed to the legislative secretary, filed with the legislative secretary, not just attention legislative secretary. So I tried to argue with the compiler that we're not we're not involved with how the Speaker of the legislature wants incoming information. But she stood her ground, and I respect her for standing her ground. And she asked that the commission re-approve these rules and regulations, send them down properly again to the Guam legislature, and then forward it for publication under the compiler laws and under the Guam administrative rules and regulations. You know, it was a blessing in disguise because of the public law. So once the public law passed, we needed to get to the rules anyway. And so here we are with these new 2024 rules and regulations. Okay.
Yeah, that does not affect any of our rulings.
No. Our rulings and our decisions and the approvals in the last several years are in accordance with statute. And the rules and regulations are in accordance with statute. So let's get going. Section 101 purpose, there were no changes to 2016 rules. Do we want to go and approve one by one, or just once we get to the whole team?
Yeah,
Okay.
I'll read it to the end.
Too many. All those in favor? The next section, there are no questions or changes or suggestions on section 101, which is the purpose of our rules and regulations. We'll go to section 2, definitions. The first definition that I've added is the word adjudicate. That is in Public Law 37-40. The word that is used for what the commission does in reviewing and hearing applications is adjudication of the applications. I thought that was a great word, but we need to define exactly what is adjudicate, and it means to consider evidence supporting an application for compensation and to vote to approve or disapprove an award of compensation in whole or in part. The key term is vote is voting, because sometimes you think adjudication is just your hearing. What adjudication is for us is we not hear it, but we make a decision and we vote on it. Any questions on that? The next is put in the term applicant. Again, with the statute that we had just passed, we added spouse, we deleted the term relative, we defined dependent. And so an applicant is a victim. An applicant can be a spouse, a child, a victim, a dependent of the deceased victim, or a person who is a private citizen under the statute. So these are the classes of people that can apply. Again, it does not include, and we have talked about this before, godparents. It doesn't include siblings, it doesn't include in-laws. We have a very narrow definition of applicant in accordance with the statute. Item C is collateral source, means an amount or benefit received or to be received from any source, whether from the offender or from a person on behalf of the offender, or from a public or private funds, and which amounts or benefits result from or are in any manner directly or indirectly attributable to the injury or death which gave rise to the award. It also includes the personal guarantee of the person for the medical expenses of a deceased victim. I thought that was good to have a little bit more broader explanation of what collateral source is. Medicare is collateral source, restitution is collateral source, insurance benefits. I think those are the most common. Any questions? Okay, we're adding food. I've added for funeral expenses, food and beverage. Musical services. Used to have choirs and musical services. And transportation of the deceased victim to or from Guam, but it does not include air or ground transportation of a person to escort or accompany a deceased victim, or for any person to attend the burial. We had requests by family members for air transportation to come from the States to come to Guam, and we denied that. So I thought we would put that in. Any questions on the? We don't pay for an escort of the body, or do you want to? There are no questions on that or concerns. Go to E. Maintenance of the victim. This one I would like some discussion, as you can see, may include the temporary lodging and relocation for the safety of the victim not to exceed 30 days. That came to my attention when I was reading the what is it, Imogene? OVC sent out to all the states revised rules and regulations for the Victim Compensation Act. And I took it upon myself to go through that and kind of look through it. I read through the whole thing and I noticed that an allowable cost for maintenance of the victim was for temporary lodging for the safety of the victim. I thought, well, that makes a lot of sense if you have to go to a hotel or some lodging. So that is an allowable cost under OVC's rules and regulations. What I have here is, if we want to do this, our water services not to exceed 90 days, used for the direct benefit of the victim, but not to include payment for personal financial debts. I have the word rent there, and I'm reading it. If commissioners have concern about having to pay water and utilities that are directed toward the benefit of the victim for 90 days, that's long. Yeah, 3 months, and our water and power bills are extremely expensive. So 90 days they get more. Yeah, they're going to get more expensive. So I threw it out there for discussion because we've never done water and power before. And if we do, is water and power for 90 days too much? But it came to my attention because if there's the maintenance of the victim, then directly to benefit the victim, water and power seems to be costs that would be reasonable. Yeah. Especially in light of the fact that temporary lodging and relocation for safety of the victim also is something that OVC finds acceptable. Any comments? I'm neither here nor there. You want to cross it out, I'm fine with it. And just stop at 30 days.
I tend to agree with it. I like to see that happen, only because we're the victims, the Guam Coalition. We have many victims who come to also other nonprofits like Alley Shelter, but they're very specific also as to what they give. Many of them just need a place to go to. Sometimes they don't want to go to a shelter for whatever reasons. So they'll come to the other nonprofits asking if we can house them, lodge them for a period of time, things like that, even though they're victims. Alley Shelter would take them in because they're victims, but they always claim that they're full. And so I think this will help alleviate. And then, of course, the power of water. They're always tend to, the victims always tend to be the ones to pay for that anyway. Certainly the perpetrator, especially with something they know. So I tend to agree.
I will intending to lean against it, so. I'm not opposed to the lodging, the relocation, I guess the burden of proof is just, I guess. Where that can be a slippery slope, I mean, I don't. We have to go back on the date, for the power and the water, I mean, again,
It's difficult.
it's like another thing to have to negotiate. That's my only reservation with the power and water utilities component.
Are you okay with the lodging and relocation?
Yes, again, it's, we know we can identify it's for the safety of the victim. I guess I'm just trying to anticipate issues with the power and water and how now we're dealing with the 19
Well,
day time frame and
we have before, but does not include costs such as our utilities, mortgage. I guess, rent will be along with temporary lodging, so. It's the. You want to go back to the way this 2016 rules had read on the water power? Don't get rid of it.
that's where I'm leaning, yeah, not including, and that's my feeling at this point, it's another thing that we're gonna have to tease out when we turn in the request. Who's the name, who's it under, who's paying for the bill? And there's a lot more things that's gonna come up that will make it a little confusing. Is it under the victim's name? Is it under somebody else's name? I think it's gonna leave more questions if we have to tease out the, rather not to tease out.
Holly, Mike, can I ask a question? You were, in terms of water and power, were you trying to merge that with temporary lodging and relocation 30 days, such as if they were to rent an apartment for 30 days, that water and power in the rental?
That would be yes, that was kind of my understanding. I assumed that this is somewhere that we go to. And then because of the rule that they have 90 days or 30 days actually. So we can limit that thing, 30 days. So it does not exceed 30. So that one power bill for that particular month, the commission can have to for their safety, as opposed to if they were living elsewhere and they were going to stay in the water permanent area.
If you go to a motel,
Already
it's included, but if you go to a rental, it's not included.
Or what if they go to a friend's house? I mean, that's where I think you were coming in. Who's on? How do we know you stayed there for 30 days? That type of thing. So I can understand that.
makes it more complicated.
So there's-
Because it's not just the victim who benefits from water and power at a location, it's whoever is there.
But if we're willing to pay for a rental, why can't we consider that as a rental? Only because the hotel can be allocated and identify those are the days that she or he stayed in, as opposed to staying in a friend's house. We don't have, unless we have an affidavit that said, yes, they stayed there.
So it's under somebody else's name, not the applicant, not the victim. Who are we paying the money on to?
Like the other vendors, I believe, we would pay it directly to
Like
landlord.
GTA or.
GTA or GTA. Under their name.
We don't have a definition also of what is temporary lodging.
Right.
relocation.
Right.
And that's where the question is, can that include rent? Rent. What comes with rent, water and power? What comes with a motel? All inclusive is, water and power. We could define lodging. We could define relocation, that's how. It needs to define it. Well, it sounds like what we don't want to have temporary lodging is, friend's house.
We have to
Is
do
that,
a license.
Because what are the hotels are booked? I don't know.
And they choose to stay in a hotel, the rate.
And then it reads,
So how do we,
how do we-
aware of what we're, what to pay? Maybe get,
that's what we put a cap. Is the relocation off either?
oh, wow. Okay, so he has opened a Pandora's box, and it's only because I did see, from the regs that they did, and it makes sense where a victim is looking for safety, and the most common situation would be a victim, goes to a inexpensive, motel, stays there for 30 days. But we don't define, what a temporary lodging or relocation is, so it could be Subaki. And we don't define.
For almost $4,000, can you take it off island? It's not like they can drive across another state. Right. Have to go off island.
And what do they need a passport?
Relocation.
And what do they need a passport?
I think it gets,
Okay, commissioners, what we could do is just go back to the 2016 rules and leave it as is. We can keep discussing this matter.
Yeah.
As we go on.
I think just to read the Barrow and other shelters, see what their policy is on relocation and lodging. And maybe we can get an idea from them. We can tweak it, and then we can come back to this after.
So Emma Jean, I know you're taking the notes here. We go back to the 2016 rules and regulations, and I believe it basically said maintenance means the actual providing of direct physical care to a victim, such as hospice, food, clothing, personal hygiene needs, but does not include cost of power, utilities, mortgage rent, or payments for personal financial debt. So we'll just go back to. Yeah. Okay. Thank you very much, commissioners. Good discussion.
we should have.
F is a medical expense. Medical expense means monetary cost involved in seeking treatment from a licensed medical provider for injury, or death. That's under the statute, so I need to put that back in there. Caused to a victim of a violent crime, as listed in our statute. It includes, the addition is it includes emergency hospital services, medical clinical services. Now, again, this comes from what I saw in OBC rules and regulations. So these are not my words. I actually copied it. Medical clinical services, mental health, counseling and care, psychiatric care, therapy, medication management, counseling, dental services, dental devices, eyeglasses, or corrective lenses, and for services rendered in accordance with traditional methods of healing recognized in law. That is something that OBC recognizes as allowable cost for medical expenses. Traditional medicine. That's interesting.
And there's something like acupuncture.
In traditional methods of healing recognized on law and acupuncture is.
I know when we were doing under medical sex, it was very broad for us. This now kind of gives it
But we asked, do we do eyeglasses?
right.
Do we do that?
I think we did.
Yes, we did. So we're right on par. So if that helps us, medical expenses is broad, but here we have,
Device.
We do have a cap at 20,000. So
Yeah.
anybody have? Dr. Parsons? All right, pain and suffering, no change, pecuniary loss. I added repair costs to property necessary for the safety of the victim or loss to the private citizen directly resulting from property damage. Property damage is generally not something we award except to private citizens. The statute allows property damages for a private citizen who comes to the aid of law enforcement or to the aid of the victim. And I think I remember, do we give property damage to the victim? No, we don't. And I was looking, why in the world is property damage even discussed for the private citizen? Only the private citizen comes to the aid of a law enforcement or to the victim and suffers property damage. Here, 161.80D is entitled to claim property damage. So I put that in. OBC did say repairs to property necessary for the safety of the victim. That would be repairing your window, repairing your door.
Very hard.
If it's for the safety of the victim. Any discussion about property damage? Subject to repair cost for property necessary for the safety of the victim. And I took those words from OBC. They qualify for the safety of the victim. And it makes kind of sense. Window, door, something's broken. Any discussion? Residency, no change in the 2016 rules. Part 2 is our general procedures. The commissioner may be reelected to a 1 consecutive term. I can't remember when my term ends.
Well, that,
But I can serve for 1 consecutive term. And if the chair if the chair is removed, then the new chair needs to be elected immediately. Here we go to the hearings, and this is where our public law comes in. Hearing shall be called by the chair. Go down further. The AG's office shall provide all administrative support. At a hearing, the commission shall adjudicate applications. That comes from the words of the statute. We adjudicate applications. We take evidence, we hear supporting witnesses, we can issue subpoenas and adopt and amend rules and regulations. Going down further, we can amend rules and regulations, legislation, review the financial stability of the fund, consider and approve fiscal year budgets, and hear public comments, and consider such matters as will improve and benefit the general community in relation to victim compensation. I did a little narrative or grammatical changes to the closed. Working sessions. Working sessions to include the general review of pending applications. I know what we try to do is receive a call from Energy, and so we can just get an idea of how many cases there are. And Commissioner Mendiola said she enjoyed that before she gets some idea, rather than just coming cold into our hearings and having to deal with it. So I added just a general idea of how many cases we have, what are they, but no decision is made, but just for the, it helps us do our job better. Subcommittee reports, communications from anywhere, program improvement and outreach efforts, as Commissioner Mendiola is talking about, we need to get out there, as well as legal assistance from the OAG. Does not require a quorum for a working session. It's informal and not subject to record keeping. Section, that was section, part 203. Part 2, section 204, our quorum. I added any decision in the absence of a valid quorum is void. Void ab initio means it's void from the beginning. It should not even be existence. It's just a legal term I put in. The vacancy, I added the commission shall notify the governor and the legislature of the vacancy for their request to have such vacancy filled expeditiously for the benefit of victims of crime. I think we have on our agenda, and we'll get to that. We have a vacancy, and I know we really need to get that fifth position filled. Absolutely. This also is a requirement under the new statute that the governor and the 1010 legislature promptly. No changes to 206, no changes to 206. There is a change in 207. At the last sentence, the commission is authorized to conduct closed meetings. Should it be closed hearings, right? Closed hearings, yeah, this is closed hearings. To adjudicate applications for compensation. Section 208 is the new one, it's brand new and complies with 37-40. Confidential records of victims or eligible applicants are protected from public disclosure under a new law. Part 3, eligibility, section 301, no change. Section 302, burden to demonstrate eligibility. I broke it down into a subpart A, B, and C. A copy of the police report, subsection A, copy of the police report containing the criminal history and investigation of the crime is presumptive proof the crime occurred. And we've often, had discussions, well, what does Imogene look at as proof that a crime was committed? Someone comes in and says, I got assaulted last night, but there is no report to the police. A police report is a presumption that a crime was committed, but it doesn't mean we disregard someone coming in and saying, I got assaulted. And we probably would say, you're still within your statute of limitations, you really should report this so we can have a police report. Invoices for services performed, payment receipts, and other financial documents are required as proof of incurred expenses. Failure to provide such documentation is ground for disapproval of an application. Imogene, we have most applications come in based on police reports.
Yeah.
Do we say you need a police report? Do we encourage them to get a police report? Because it certainly is like I said, we have now, if we adopt these rules, this is the presumption that the crime was committed, and it's when we actually start counting the statute of limitations.
What's the date of the incident?
The date of the incident. If it's the police report, we start counting that date. The more difficult situations is where a victim doesn't file a report. We haven't had a situation like that, but we'll deal with it if that date comes. But we do encourage use of the police report, and hopefully most victims are they report the crime committed against them.
Is a report, when the police report is filed or dated, is it the date of the injury or is it the date when it was filed? So the
Police
injury that
report.
happened.
Yeah, the police report will have date of injury. Or date of crime, yeah, the date of, so that's what we need. Because sometimes police officers take a few days to
Right.
get it into the system.
Understood.
You've seen those.
Yeah.
So the police reports, do have date of crime. B is operation of a motor vehicle, boat or aircraft while impaired or under the influence of alcohol or drugs in violation of the Safe Streets Act. With a blood alcohol level or drug impairment over legal limits, the legal limit is 0.08, is sufficient to prove intent that a crime has been committed for purposes of this act. This was in some of my discussions with Assistant Attorney General Janice Camacho regarding driving and proving intent that a crime was committed. When you're drunk driving, you intend, when you're driving drunk, that you're gonna kill somebody, probably not. But if you are over the 08 limitation, then the presumption is you committed a crime because you went over them. So I thought we should put that in here, for in line with burden of proving eligibility that a crime was committed. The last one is C, medical expense is, and this is something that I've raised before, is personal to the applicant, does not survive the death of the applicant unless the application is filed prior to the death, in which case the proceedings may continue before the commission or the legal representative of the decedent's estate. We've had situations where victim has incurred expenses, an adult victim has incurred expenses and has passed away, and a family member who was a personal guarantor to the hospital came in requesting compensation, and in one case I voted negative, but the commission was unanimous. We did approve that. Subsequently, I understood the commission's position, but I still think that it can go forward, but it has to be the estate, and that's in the statute. The state of the victim is the one who should come before the commission requesting compensation so that the estate is made whole. Not that the personal guarantor is. Anybody else's thoughts? Do you remember Janice saying that we've approved those claims because even though a mother guaranteed to the hospital, the services were for the benefit of the victim, and that's what Janice focused on. The services of the hospital were for the benefit of the victim. Victim dies. So we said, well, since the benefit of the victim, we will pay them off. That way the mother, the applicant, was not burdened by while Memorial Hospital going after. But C would disallow us from doing that. And it would have to be a probate and an estate person coming in. Don't have to have it. Do you want it or not?
I can say.
Unless the victim filed before first died. Been injured and then died after having.
You've seen people die during the situation in the emergency. They have to have off the bill, and so the person dies.
They've come here to apply for compensation because the services were rendered for the benefit of the victim at the time. And that's where I heard Janice and I bicker back and forth legally. My position was because section 151.115 of the statute reads pretty much what C said. The medical expense is personal to the applicant and does not survive the death of the applicant. So the applicant, if a victim died and didn't That's it.
It is.
It is. If the victim, apply and dies, well, then we need a representative.
Their victim and they may not ever have regained consciousness to have thought to apply.
Correct.
I struggle,
Yeah, I, like, I need to feel it, the guarantor. The person I thought,
yeah, I am not comfortable.
because I don't think I have a choice, that the emergency, someone has to.
You have to, the patient may have to sign, but.
But I think a lot of folks are not,
you're
and
not-
where you're in shock that your relative or whoever is
You're
there,
fine.
they're just like whatever. I don't think they know half of what they're signing. And so
I need to come to
to
you.
leave the burden on the family member, for me, that is struggle. Victim wouldn't have been in the situation they were in. Yeah, criminal.
And I think, Dr. Flores, you raised a very strong position that the commission has taken previously in these types of situations, where I have raised my concern as a lawyer. When the statute says the medical expense is personal to the applicant and does not provide the death of the applicant unless the applicant dies. And that's what the statute, but we don't have to put it in the rule.
I'm trying to figure, where is that in?
Okay, let's get the statute. 161.115. It's called survival and abatement. Do you have that? Page 17 of the statute. Well, while we're giving Dr. Flores some time, anyone on the chat? Anybody from the public?
So the other recourse for the family member would be, restitution.
Restitution bill is the So when Janice and I were going back and forth, I pointed 115 to her, and she says, "Your Honor, you might be right." It's personal. So the right to compensation is personal to the victim. It does not survive the victim's death as the victim or beneficiary does not survive the death of the person or beneficiary entitled to, provided that if such death occurs after the application of compensation has been filed with the commission.
Beneficiary potentially be the parent who's signing off on the guarantee.
Such as,
Or common in-law.
yeah, let's take a common law beneficiary. Provided that if such death occurs after an application for compensation has been filed by another with the commission, the proceeding shall not abate, but may be continued to legal representative of the state. Dr. Floyd, you're absolutely right. I know people. How do I open a probate? People don't do pro se probates.
Very expensive.
It is. It's to start it, you need at least $5,000 just to go through the notice process and the time and.
I don't think that people have anything to pass on to somebody else. They got a bill. Unfortunately, that bill is what they are passing on to someone else. But beneficiary, I guess, fine head. Not a benefit, but
It
it's
says, but
what they've inherited. as a result of a criminal act.
I like the term beneficial. Do you want to delete C and just go with the statute is written? Because the statute is written in more, except legal representative, it says may continue with the legal representative, or we may want to continue with somebody else. It's not.
But I think second, that's probably making that if theory would probably.
We go with whoever is the beneficiary.
I know we. I go to. Take C out.
Okay.
That's that.
All those in favor?
Aye.
Aye. Deal. Thank you for that decision. Part 4, and we're almost done, and on pages, the application form, section 401, approved by the commission, so, we used it,
It's just-
statute of limitations, I'm sorry. Section 303, statute of limitations, thank you, Mike. I put the words of the victim because that's in the statute, 6190A, does say death of the victim, so that is. Part 4 is the application form process. So we used to attach the application form A to our rules and regulations. I recommend we don't do that because it gets promulgated under the rule process. We need flexibility. So the word is the official administrative form approved by the commission. But don't attach a form to this. 402 is review of eligibility and completeness, referral to the commission. I think it used to be the OAG, but I put the administrative staff of the commission. We are becoming a more viable commission with administrative staff, like MOG. A, B, C, D, D, instead of using the word allowable losses, because I don't know what that is, we have a definition of pecuniary loss. And the definition of pecuniary loss refers to the maintenance care of the victim. E, no change. F, we add the word adjudication. Part 5 is the hearing. These all come from pretty much the new law. Hearings of the commission must comply with open government except as authorized in these rules and the law. Hearings pertaining to administrative business are open to the public. Adjudicative hearings pertaining to the taking of testimony, evidence, in support of an application are closed. The commission is authorized to hire an ALJ to conduct administrative hearings, and if somewhere in the future we want to be able to do that. On behalf of the commission, to make dispositive recommendations to approve or disapprove an application for compensation or in full or in part. So an ALJ that we hire merely makes the recommendation up or down. No changes to E and F and G. H, I changed, added an applicant who is not represented by counsel may present questions to the commission for consideration, which means that if the witness, I'm sorry, the applicant would like a question asked, the applicant cannot be the one asking the question, but can submit to the chair, and we ask question. If I determine or the chair determines that it's an inappropriate question, then I'll ask. So I don't think an applicant should be allowed to cross-examine a witness, but should be allowed to ask questions that, and this just comes from my judicial days. When we have a pro se, I try to restrict what a pro se can ask and can get out of control. So as a judge and as a chair, I think we need to screen the types of questions that an applicant can ask them.
I go back to E.
Yeah.
What do you mean by hearing shall be formal rules of that?
That's usually what is used when you're not in a full legal trial type situation.
That'll be considered formal.
Court procedures are formal. Civil Service Commission, this commission, any other administrative type agency does not follow rules of evidence. You want to say that because once you get into that, then it's objection, rule Rules of evidence are primarily for court. Does any commissioner have any questions with, allowing us to screen questions from the applicant? J, K, and L, no changes. Section 502, medical examination, no changes. Part 4 is decision and appeal, changes to 601B. When the hearing is conducted by an ALJ, the ALJ shall render a recommendation to the commission within 20 days of the hearing. An ALJ is normally a law trained lawyer, and so 20 calendar days, they should be able to go through all of these, make a recommendation. The commission may accept or reject the recommendation. Recommended findings and conclusions of the ALJ, the commission may review the record de novo to decide whether to accept or reject the ALJ's recommendation. I would assume that it's going to happen where the ALJ says deny this, and you might have some concerns. We don't have another hearing, we just go back to the record, which Will records and Imogene keeps record of. We listen to that and then we make our own decision. The commissioner shall notify the applicant in writing of its final decision. So ALJ can hear it, make recommendation, we can accept, we can reject it, we can go back to the record, and then we must notify the applicant of the final decision. I think we do such a great job, we don't need the ALJ, but it's always nice to have the option of the ALJ. Reconsideration I added is limited to the record. We don't take more testimony, we just listen to the record. And that might come in a situation where someone, if we reject an application and they ask for a second time, I'd like reconsideration. We don't have another hearing, we just listen to everything forward. 603 is an appeal process, no change. Part 6, 604, finality, no change. Part 7 is attorney's fees. I added on 701, compensation awarded on these amounts is aggregated for all existing and future expenses incurred by the applicant. I don't know if I got what was in my mind through in that sentence. Applicant comes in, files, and during the course of medical treatment, there are more expenses that come up as time goes on. And I wanted to say something to the effect that once we award an amount, that takes into consideration what's here and what may occur. Otherwise, we award here and then come back and want some more, and we haven't really had that situation.
Affecting the psychological services as a result of the they can drag on. I'm not sure if we award it. We usually award it because there's receipts that come in that we say okay, but not what you're doing last year.
Well, I can see a situation where they come up with receipts for treatment after we make an award. But we've already made an award. So basically what I want to say is when we make an award, that's it. It ends everything, all the receipts, everything before that. And there may be future medical expenses. But compensation awarded on these amounts is aggregated for all existing and future expenses incurred by the applicant. Maybe I didn't say it quite correct. Is there another way of saying it?
How do we justify the future of projected? There we have this. The table, you just kind of toss it to, this is an award, we're not, you can see for the term, we're not making any goal. There are other avenues to kind of do. So. Because it kind of, Yeah. We've had some cases, I think, some cases where we said, okay, do what you need to do, we will table this, come back again, and then once we make a decision, we can inform them that, that's it.
Otherwise, they kind of either unlimited or up to the next board.
You know,
And there's the statute. But again, I think our goal, we kind of focus on, we're not fixing it. There's one little option for providing what we can. We're not gonna make you whole based on what we're owed.
So at this point, is this way, is the kind of thing that we can do.
The past, other people never had this opportunity. This is something, not nothing.
and that's what I'm trying to get at. We're not here to make an award for your future expenses. It's for expenses incurred at the time that we hear the case and make the award. That's it.
Yeah.
So compensation awarded on these amounts is aggregated for all existing expenses incurred by the applicant, or we can just take it out. Because I think our discussion here gets to that very, very point. We don't go beyond what the receipts are for expenses incurred when you hear. That's what
We basically think this.
So
is a term in compensatory damages which awards report your future losses and stuff, but we're not. Commissioner, why don't we just leave it? All right, motion, and those in favor, I'm going to delete it, okay? And the last one is attorney fees. Commission may order reasonable attorney's fees based on an award granted to an applicant pursuant to statute. The commission may require the attorney to submit, an affidavit of reasonable attorney's fees to the commission within 30 days of the issuance. The Board of Attorney's fees is not subject to reconsideration. And with that, commissioners, I'll ask one more time, are there any persons in the public who have participated and would like to ask a question on these rules and regulations? Will, is there anybody in the chat room?
Nope.
Okay.
No one has any-
Commissioners, we are done with our rules and regulations. And I would like to get this to the Attorney General of Guam, discuss this with Fred, have him review it, send to the Attorney General and prepare a correspondence with the Attorney General to Speaker of the Legislature ASAP. Yes, please. May I have a motion?
I make a motion to. To approve this amendment
To approve the rules and regulations as amended. And all those in favor signify by saying aye. Aye. Ladies and gentlemen, the Criminal Injuries Compensation Commission Rules and Regulations for the Adjudication of Victim Compensation 2024 is formally adopted on March 1st, 2024. Thank you for that. That is awesome. Oh, hopefully we can just get to the work of applications and the future. We will go down to request to the governor, which is a new business item E, request to the governor to fill the vacancy. Would you, does anyone just want to talk to the governor? I'll make a formal request. You know, I need to go. If we know of a candidate, we can represent the governor.
I know it's what the name is. But I don't remember, there's no that I'm doing. But I do have a question, do we go with our? I feel like I'm.
You're okay.
You don't know what I'm doing.
MG's gonna let us know. Let all of us know.
Yeah.
Feels like it's coming up, right?
And then we spent our time going back down and like. You were the last one. You were like 2025 or 2026.
around the corner too. Figure out. That was that.
Yeah,
And would you please, if you can let us all know, that would be great. And I'll prepare a letter. If you don't mind, I'll sign it. Send it to the governor directly to go and do this today. And with that, we are on recess from live broadcasting, ladies and gentlemen, and to the public. We will now go into our adjudication portion of the hearing, which is closed under public law 37-40. And with that, Will, if you can take us off of YouTube, we will continue the work